Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. We're in the return of interest balancing in Duncan versus Bonta, the en banc of March 2025, specifically in Judge Bumatay's dissent. We're on page 112. I'm going to share my screen. I'm sharing it. Feel free to call me Sharon. Here we go. The majority upholds California's magazine ban despite Heller, McDonald, Bruin, and Rahimi. Don't forget Cayetano, Judge. Don't forget Cayetano. That was per curiam. It's part of the precedent here as it relates to common use. Judge Bumatay, don't forget. In doing so, the majority rejects the Supreme Court's Second Amendment framework and reads the amendment as it wants. Let me just add something here. Okay? Maybe this is uncouth for me to say, but I think what you're saying, Judge, is the majority, the Democrat majority on the Ninth Circuit, rejects the Republican Supreme Court Second Amendment framework. Isn't that what you're saying? Am I right or am I right? Or am I right or am I right or am I right? And you hear people say elections have consequences. Yeah, yeah, yeah. First, the majority haphazardly establishes two Bruin tests, the so-called more nuanced and unnuanced approaches. If that sounds confusing, it is. In fact, it's so confusing that the majority largely abandons its own creation mid-opinion. Oh my gosh. You can't make this up. Second, rather than examine historical analogs for their similarity with California's regulation, the majority simply cloaks interest balancing under the guise of tradition. So, in the Ninth Circuit, we've returned to the old days of judicial policy making that the court has gone out of its way to end. A, the majority's nuanced versus unnuanced approaches. To begin, we can't ignore the majority's creation of alternate Bruin tests, what it dubs the more nuanced approach and the straightforward, unnuanced approach. Well, I'm glad that you say that you can't ignore that, because that does seem to be the Democrats' strategy is just to ignore the Supreme Court, uh, and then just hope that the Supreme Court doesn't have time or thinks it doesn't have time to defend the Constitution on this issue. I think that's the game that's being played here. Plucking a few words from Bruin. Oh, by the way, they ignored Heller. So, I mean, isn't Bruin just an outgrowth of Heller? And they ignored Heller in coming up with the interest balancing. Um, who said that? Well, I'll tell you who said that. It was Judge Kavanaugh that said that on the D.C. Circuit, writing in dissent in Heller too, in 2011. You can see it in the 670th volume of the third series of the Federal Reporter. Look under DC Circuit, you'll see it. That's assuming you ever go to the law library and look at volumes, which maybe you don't, but I do. Plucking a few words from Bruin, the majority claims it may apply a more nuanced approach anytime a regulation involves unprecedented societal concerns or dramatic technological changes. Although it's unclear what precisely the majority means by a more nuanced approach, it appears to mean that we may disregard our historical tradition of firearms regulation whenever, whenever a modern regulation seeks to address modern problems or technology. Exactly. That's right. You nailed it, Judge. Instead, we're on page 113. Instead, whenever that is the case, the majority calls for a more flexible analogical approach. This flexibility apparently means that no analysis of historical analogs is necessary. All that's needed is a determination that there's a difference between technology or societal problems at the founding compared to today. Yeah, pretty much. Um, so the majority's more nuanced approach is more accurately termed the ahistorical approach. There's much to dislike about the majority's creation. First, the Supreme Court has never endorsed a more nuanced versus a straightforward, unnuanced approach. Indeed, it would be remarkable if the Supreme Court were forming two sets of Bruin tests without telling anyone. So the majority's test is just its own invention. Instead, there is one approach. The Second Amendment's text and historical understanding always control. The majority claims to just be, can we get rid of these split infinitives there, Judge Bumatay? The majority claims just to be quoting Bruin, but take Bruin's comment in context. While the historical analogies here and in Heller are relatively simple to draw, other cases implicating unprecedented societal concerns or dramatic technological changes may require a more nuanced approach. That's at Bruin 597 US at 27. On page 114, the court's note about the occasional need for a more nuanced approach was an unremarkable observation that making comparisons to proper historical analogies might be challenging at times. Indeed, historical analysis can be difficult. It sometimes requires resolving threshold questions and making nuanced judgments about which evidence to consult and how to interpret it. That's especially the case when unprecedented societal concerns or dramatic technological changes may make analogical reasoning relatively tougher. Bruin and Heller's historical analogies, in contrast, were relatively simple to draw, given the extreme nature of the bans. So the court was simply cautioning lower courts to be careful and thoughtful in scrutinizing the government's claim of historical analogs. Simply, no approach that ignores history adheres to Bruin. But in the majority's telling, Bruin's discussion of a more nuanced approach was the court silently embracing a whole new test in cases involving unprecedented societal concerns or dramatic technological changes. And how do we know that the majority is wrong in developing its two test regime? Just read Rahimi. That case makes no mention of the majority's nuanced, unnuanced distinction. Now, look, let me clarify something in case you're not catching this, all right? Pay attention. Are you paying attention? Pay attention. Focus. I need you to focus. America needs you to focus right now. Okay. Who's writing this? Who are we reading? We're reading Judge Bumatay, Ninth Circuit, Duncan versus Bonta en banc. This is like the fourth time it's been en banc. And this was published. When was this published? Well, you can see it up here. It was published 2025-03. That's March 20th. There you go. It's published on March 20th. So when he says the majority here, how do we know the majority is wrong? What majority in what? In Bruin? No. In this en banc case that Judge Bumatay, a Trump appointee, is writing in dissent to. Dissent. Okay. How do we know the majority is wrong? The majority here, the Ninth Circuit, the Democrats. I'm just going to say it's the Democrats in California and on the left coast. It's left coast Democrats. How do we know they're wrong in developing its two-test regime? Just read Rahimi. That case makes no mention of the majority's nuanced, unnuanced distinction. If this two-test method were so central to Bruin, we would expect that the court would at least say something about it in its very first case applying Bruin. Instead, we get zilch. Undeterred, the majority plows ahead with its creation. Yet it has no explanation for Rahimi's silence on the two-test framework. It fails to explain whether Rahimi is a nuanced case or an unnuanced case. It skips all of this and just moves forward with its made-up analysis. Page 115. But it gets worse. The majority also makes clear that its more nuanced test is a repackaging of this circuit's old interest balancing regime. Wow. Wow, wow, wow. The majority holds that when governments deal with modern technology or problems like mass shootings, they need even more flexibility, and thus the government's regulations are constitutional. Yeah. That would be great. Yeah, that would be great. The problem is that it's not just governments. This is me inserting something here. It's, Democrats always assume that it's governments that are dealing with things like mass shooting. Governments investigate them after they're happening, but it's private citizens that are dealing with it in the moment. Am I right or am I wrong or am I right or am I right or am I right? It's the individual in a self-defense situation that's dealing with it. And those are the plaintiffs here. What about them? The Democrats don't even think about the individuals that are suffering, that are the victims of these horrible crimes. You know, it's like such a huge blind spot. Why would the victims not need more flexibility in dealing with criminal activity directed toward them in the moment when the police are not there to protect them? And by the way, the police have no legal obligation to protect any citizen except those in custody. There is no duty to protect the public, any individual in the public, for the police. That means you're your own first responder and you need the flexibility. Back to Judge Bumatay. All of this is just code for judicial interest balancing and policymaking. Under this balancing regime, there's no look to the historical meaning of the Second Amendment, only a review of technological or societal change and whether that change justifies the government's regulation. They're such brats. They just only think of the government. They only think of what the government, what's better for the government. These Democrats. So the more nuanced approach appears to be little more than reinvigorated judicial means ends scrutiny in fancy dress. In the end, we have no doubt that this more nuanced approach will resemble our old black box regime where judges simply uphold favored laws and strike down disfavored ones. Besides flouting the court, this two-test approach makes no constitutional sense. The Constitution enshrines enduring principles. That means that the Constitution doesn't so easily bow to technological or societal change. In any other context, we would scoff at the idea that the Constitution grants broad deference to the government simply based on the modernity of the problem. The free speech right didn't change when the internet was invented. The Fourth Amendment right didn't succumb to new technology. In none of these cases have courts just thrown up their hands and declared that the government needs more flexibility. So the majority's creation is a grave mistake. Now, I think it might be helpful for you here if we just do something like called looking at the Constitution. So I'm going to pull up the Consta-Frickin-Tution and we're going to shine it on the screen. He mentioned comparing the Second Amendment with the First Amendment. And why do you think he would do that? He said that the internet is unprecedented technological change. Does the free speech or free press get any less protection? What about the freedom of religion? What about the freedom of peaceable assembly? Because it's the right of the people. This is the key part right there. This is clearly a right of the people, and the people are, as opposed to in this, the government. It's not a right of the government. These are not rights of the government. They're rights of the people. The Second Amendment has the same language of the right of the people. And so the right of the people, as opposed to what? The government, as opposed to the government. In the Third Amendment, it's pretty clear that this is a right of the people. In the Fourth Amendment, it's explicit again. The right of the people, right? The right of the people. It's right there, this phrase. So that's why he brought up the First and Fourth Amendments. These are the appropriate textual analogs in regards to who is being protected there. Who's being protected? It's the right of the people. The right of the people to be secure in their houses, persons, papers, and effects against unreasonable searches and seizures. In the Third Amendment, owners are protected, right? Those are the people. The right of the people to keep and bear arms shall not be infringed. The First Amendment is very clear that the right of the people is as opposed to the government. They're not the same thing. And so we move on in our analysis. Any questions or comments, put them down below. We're on page 116. In the end, perhaps recognizing its vast departure from the court's directives, the majority, that's the majority here in Duncan versus Bonta en banc, the majority retreats from its two-test approach mid-opinion and purports to apply Bruin. The Democrat majority on the Ninth Circuit in this en banc case retreats from its two-test approach mid-opinion and it purports to apply Bruin as directed by the court. Even then, the majority still gets it wrong. We turn there next. B, interest balancing as analogical reasoning. By now, it should be clear what courts should do at Bruin Step 2 when analyzing the government's justification of its gun control laws. We look to whether the modern regulation imposes a comparable burden on the right of armed self-defense and whether that burden is comparably justified. Our task then is to see if historical analogs point to a limit on the Second Amendment scope that justifies the regulation. In other words, we decide whether the how and the why of the government's regulation and purported historical analog are relevantly similar. Unfortunately, the majority botches this analysis. Rather than examine historical analogs for their similarity with California's regulation, the majority cloaks interest balancing under the guise of tradition. But it's easy to see the majority's sleight of hand. We break it down step by step. Step 1. The majority starts off by assessing the magnitude of California's magazine's ban's burden on the right of self-defense. This is definitely interest balancing. This is definitely the same thing that they were doing before. In other words, what Bumatay is complaining about here is you have a major case, Bruin, in 2022, and the court proceeds as if that never happened for all practical purposes. They're using the same analysis as before, as if nothing changed. It's amazing. But it's not really amazing if you know how Democrats think. This is how they think. They think that we're going to do it our way and we're going to get away with it if we can. So it concludes from that part, the burden is only minimal. Well, this is tiers of scrutiny right here. Yeah, it's only minimal. Yeah. The majority asserts that the burden is small because California's law didn't go further. Wow. This is amazing. The law also imposes no limit. This is on page 117 now. The law, blah, 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 blah. Okay. Instead, wow. Instead, the majority says that the law prohibits only one very specific use of some firearms, the shooting of an 11th or successive round without reloading, and concludes the burden is minimal. Okay, I gotta clarify something here because there's a real basic problem here. Um, there's a real basic problem. Did you catch it? Yeah, I mean, let's take a look at Bumatay's mistake here. The shooting of an 11th successive round. Well, if you have 10 in the magazine, you can have an 11th round in the chamber. So the 11th round would not be illegal under this. A 12th round would be. Does that make sense? This is where we get to, when we get to Van Dyke, you'll see the familiarity with firearms is required. It's not optional when you're regulating stuff like this. If it's going to make any sense, I mean, you got to be able to get the numbers right. At least you're not dealing with crazy numbers here. So this is just a basic flaw without reloading. Yeah, you can do 11 rounds without reloading. This is basic firearms and understanding, really basic, like kindergarten basic. Okay. Then it claims that people rarely use magazines holding 10 rounds in armed self-defense. All this ends with the majority just declaring that these magazines are no weapon at all. Okay, so it's a very minimal burden on law-abiding people because they're just not very useful in self-defense. I think that's what the Democrats are claiming here. Um, the majority again falls for the fallacy that using a firearm for self-defense equates to pulling the trigger and firing every round. But the natural meaning of bear arms is being armed and ready for offensive or defensive action in a case of conflict with another person. So the right of self-defense isn't measured by how many bullets are expended. It's determined by how law-abiding citizens choose to ready themselves in case of conflict with another person. Um, our criminal laws don't require a firearm to be discharged for it to be used, right? That makes sense. So, in other words, they know better. The Democrats here know better. Um, all that matters is that California's total ban on possession of magazines capable of holding more than 10 rounds amounts to a prohibition of an entire class of arms. We're on page 118. That is overwhelmingly chosen by American society for the lawful purpose of self-defense. Even the majority concedes that California bans magazines that enhance a person's ability to fight or defend himself. And it's hard to see how the majority's burden analysis is any different from its step one conclusion that these magazines are not an arm at all. So the majority just confuses the step one and step two inquiry. In any case, we proceed with the majority's interest balancing. Step two, having arrived at its stylized burden, the majority moves on to analyze historical regulations' purported justifications. Misreading history and attempting to extract the broadest of generalities, the majority manufactures a tradition of regulating a particular, especially dangerous use of a weapon once that use becomes a specific threat to innocent persons. As uses of weapons, once those perils, sorry, as explained above, no historical analog supports this made-up tradition. And in reality, the majority just seeks to recognize a broad public safety justification for government regulation. That's exactly right. He nailed it. Under the majority's view, this justification gives states the ability to regulate any arms for public safety. Such a justification swallows the entire Second Amendment right. There you go. Step 3. The majority then makes a factual leap, finding that magazines holding more than 10 rounds fit the bill of an especially dangerous weapon. In the majority's view, large capacity magazines exacerbate the harm caused by mass shootings, and limiting magazine capacity thus prevents or mitigates the harm caused by mass shootings. So it's fascinating that they get that from anything in reality. It's amazing. Of course, the majority cites no facts to support this. Even more, it doesn't even explain how these magazines are especially dangerous firearms or what baseline it makes this comparison. What baseline makes this comparison? On page 119 at the top. How are we to decide when a firearm is just dangerous versus especially dangerous? Only the majority knows. And I would say, Judge Bumatay, let me correct you on this. Only the majority claims to know. I don't think they really know. Step 4. The last step is the majority's comparison of the burden of the magazine ban to the supposed justification for outlawing especially dangerous weapons. In the majority's view, because the same justification underpins California's restriction on magazine capacity as historical laws, and because California's ban imposes less of a burden on armed self-defense than some historical laws, it is constitutional. In other words, it takes a broad justification, the why, and compares it with a minimal burden, the how, and finds a match. That's very interesting. If you're confused by that, well, let's keep going. So rather than compare the justifications and burdens to relevantly similar analogs, the majority just looks to the fit between a generalized why and an in the ballpark how. But this crosses wires. We are not supposed to compare the how to the why. We're supposed to compare the how and why of modern regulations to the how and why of analogous historical regulations. If the historical and modern regulations share a common how and why, then this may reveal that the regulation is outside the scope of the Second Amendment. Put another way, we must see whether California's magazine ban works in the same way and does so for the same reasons as historical regulations. That's Gorsuch concurring in the Rahimi opinion. Instead, the Democrat majority here on the Ninth Circuit merely points to some historical whys and some historical hows and calls it a day. Although they try to disclaim it now, make no mistake, this is what the majority has been doing and continues to do. Take the majority's analysis of Bowie knife and slingshot regulations. The majority claims the regulation of both weapons support its supposed tradition of regulating especially dangerous weapons. But it also acknowledges that the only historical uh, burden on those weapons was to ban their carry outside the home. So even if the majority were right, the justification of regulating especially dangerous weapons only leads to the prohibition of carrying the weapons outside the home, not outright possession bans, as California enacts. If comparing the how to the why of a regulation sounds familiar, it is. It's interest balancing 101. That's good right there. That's really good. Yeah, this does all sound familiar, doesn't it, Judge? Yeah, that's because they were doing it before the new precedent, which they're ignoring. This is interest balancing 101. This time, masquerading as a respect for the Second Amendment's historical scope. The majority's analysis bears all the hallmarks of judicial means ends balancing. Determining first whether California's interest is compelling, then assessing the severity of the burden, then evaluating whether California's means fit its end. Look at the majority's language pre-Bruin and post-Bruin and notice how little has changed even after the majority attempts to mask its defiance. Let's take a look at these pre and post Bruin. Let's just take a look. Amazing, isn't it? Majority pre Bruin. Large capacity magazines tragically exacerbate the harm caused by mass shootings. Majority post Bruin. Mass shootings are devastating for the entire community, and large capacity magazines exacerbate the harm. Looks identical. In other words, this is setting up compelling interest for the government. California's ban on large capacity magazines imposes only a minimal burden on the exercise of the Second Amendment right. That's pre-ban, pre-Bruin. Here's post-Bruin. California's law imposes only a minimal burden on the right of armed self-defense. Okay, so there's the analysis of how burdensome the right is. To the right it is. Here's the third box. Pre-Bruin, we conclude that California's ban is a reasonable fit. Wow, reasonable fit. That's language of, well, it's supposed to be intermediate scrutiny, but it sounds like rational basis to me. We conclude that California's ban is a reasonable fit, even if an imperfect one, for its compelling goal. Oh, there's the compelling language. That's what's supposed to make it intermediate scrutiny. The compelling goal of reducing the number of deaths and injuries caused by mass shootings. Here's post-Bruin. It's prohibition on a weapons component that serves the sole function of enabling a specific, especially dangerous use of a firearm fits neatly within the tradition of banning especially dangerous weapons. Fits neatly. Okay. And then lastly, pre-Bruin, California's ban on large capacity magazines is a reasonable fit. Wow, there's a language of reasonable fit. That is rational basis or intermediate scrutiny masquerading as actually rational basis masquerading as intermediate scrutiny. Reasonable fit for the compelling goal of reducing gun violence. Here's post Bruin, California's modern law justification for burdening the right to armed self-defense fits the need to protect innocent persons from infrequent but devastating harm. Bruin did two things. Thank you, Judge Bumatay. Bruin did two things. We're on page 121. 122. Bruin did two things. It ended judicial interest balancing and did it though? Because here they are doing it, Bumatay. Yeah. Bruin did two things. It ended judicial interest balancing and it provided a new framework for considering Second Amendment challenges. Yeah, but the Supreme Court the Republicans on the Supreme Court have to show up for the Second Amendment. They can't just let this fly like they did for years after McDonald versus Chicago. So, Bumate, we salute you, our hands off to you, because you're doing great work. Thank you. Thank God you're on the Ninth Circuit. God bless you, brother. It provided a new framework for considering Second Amendment challenges. Despite this revolutionary change, things remain the same in the Ninth Circuit. Faithfully applying Bruin requires a course correction that the majority refuses to take. Instead, the majority just declares it knows better and charts its own path, but that disrespects the Supreme Court and the rule of law. Conclusion: at each step of this case, the majority has made clear its disdain for the Supreme Court's Heller, McDonald, Bruin, Rahimi jurisprudence. Don't forget Cayetano, man. Come on, dude. Let's look up Cayetano, shall we? Let's do that. Let's do it together. Go to Giggle Scholar and we'll look it up together. What do you say? Pick you up any time of day. I'm going to Giggle Scholar and we go to case law, federal courts, and we go to Cayetano versus Massachusetts. And where are you? Whoa, hold up, yo. No, not in the Ninth Circuit. What the heck? Oh, man. Versus Massachusetts. There we go. 577 U.S. 411, 2016. Jamie Cayetano versus Massachusetts, per curiam. The court has held that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding, and that this Second Amendment right is fully applicable to the states. It had to do with stun guns. Notice the question comes up because they're in common use. And Justice Alito and Thomas concur. It's per curiam, though. I don't think there are any dissents here. I might be. Yeah, there's no dissents here. There's no dissenting opinion in Cayetano, guys. 2016. This is during Obama. So I feel like this is a major Supreme Court decision. This is during Obama. In fact, this was right after Scalia died. Oh, man. That makes me sad thinking about it. That means, well, let's think about this. Hold up. March 21st, 2016. Yeah, I'm just now realizing, when did Scalia die? He died early in 2016 he died, yeah, February 2016. I remember because I was in class with Professor Michael Uhlman, and he got a call. He never took calls on his phone. I mean, I didn't even hardly know he had a phone. I mean, I know he did because I called him, but during class, he took a call from Maureen Scalia, Justice Scalia's wife, early in this semester to talk about the funeral. And it was a little bit odd being in class, in a law class, and the Supreme Court justice dies. And, I think it was just very soon after that my professor's getting a call from the wife of the guy that died. So this is after. So this means there was a 4-4 on the Supreme Court. At the time of this decision, it was pure per curiam. That means at least one Democrat. Well, there were no dissents. Presumably, it's 8-zip on this. The Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding, and even those that rely on modern technology. So I don't know why Bumatay is not citing this case. I don't understand that. Um, but just letting you know that he should be citing it right here. And I think it's even more significant because Scalia was not on the court during that time and he hadn't been replaced, which means there was a 4-4 split. Oh my gosh. Except for there were no dissents in that case. There were dissents in Heller and McDonald and Bruin and Rahimi. But in Rahimi, there were no splits based on an animus to the Second Amendment, unlike in Heller, Bruin, and McDonald. Well, we're getting into Van Dyke after this. Um, I've enjoyed this time. Thanks for joining me on the Republican Professor podcast. I've been your host, Dr. Lucas J. Mather. I've also been my own host. It's it's 7 June 2025, years after Jesus. It's a Saturday. I got to open up the church tomorrow. I'm on staff. I preach the next week, not tomorrow, but the next week after that, Trinity Sunday. So I won't be doing a Saturday episode next week. We'll catch you later. By the way, if you don't know God, if you don't have a personal relationship with the Lord, what in the world are you thinking? Get on that. Talk to you soon.